Can you hear me? All okay?
It's LB.
Yeah. Hi. Good evening there.
Hello, hi everyone.
Yeah. Mic testing. So we got another 2 minutes. So, do we see any people online? Hello, everyone. Hang in there. We'll get started in a couple of minutes or maybe a little more while we all gather here. Yeah. Very good evening, Adya. And yeah, this is exciting times, right? Hey, hello, everyone there. Ajit, Matthew, Anand, Tejas. Hey, Dilan. Hey, Simran. Atharva. Yeah, I think yeah, we have around 50 people on the stream. Hey, good evening there in India and good morning or just good afternoon, everybody here in United States. All those folks in India, thank you so much, including Adya, for making time 9:30. I hope you had a wonderful dinner and this may be a little bit of learning time after dinner. Here in US, of course, lunchtime and some of my Pacific friends, of course, there's kind of morning time here, and folks in UK or Europe, kind of I think 5 p.m. Thank you joining for this wonderful excitement here. I think we are all excited that um, the the democracy or fifth largest economy or the new digital India has a data protection law which is coming into effect. We're going to talk a lot about that. I'm super excited, and everybody is. I think that's why we see so much response there. So just gonna put a context. My name is Samir Ahirrao, and I'm founder and CEO of Ardent Privacy. I've been lifetime data security technology slash privacy professional. And Ardent is privacy technology company operating this space for quite a while now. So especially also focused on the Asian and Indian market along with US. So we wanted to put it out there. Hey, no, there is a lot of excitement. Why don't we take this live and do that? So the context here is being a fifth largest economy, and especially the initiatives like Aadhaar, UPI. I think barcode-based payments, and there is so much data collection of almost 1.4 billion. So Gartner predicted that in 2023, like 65% of the population will be covered by some, and I think that estimate may have been already exceeded with such a huge economy and all that. So super excited, a right first step towards this. So let me actually have a privilege of introducing right the law panel. I'm a personally technology, so I wanted to cover the law, right? What is out there, and I think it's a lot of legal aspect before technology comes in picture, and everybody must be wondering about and hey, what is? And of course, there are some good thought leaders who are putting a lot of great content. So I wanted to put somebody from legal, and Spice Route Legal was kind enough. Thank you, Adya, for helping us there. So Adya is a practitioner. I wanted to give a very specific or kind of information at the practice level. Law has a lot of things, and so we'll go into intricacies of that as much what allows us in next 45 minutes or so. So I'm really excited to have that. So Adya, why don't you actually go ahead and introduce yourself rather than me doing job? Please.
Thank you, Samir, and thank you for having me here. This is super exciting. Quick introduction. My name is Aadya Misra. I'm a counsel with the Data Protection, Privacy, and Cybersecurity team at Spice Root Legal, which is a full practice law firm. We spend a significant part of our time thinking, advising on, and helping stakeholders tackle privacy and data protection issues. What does that mean? It means legal advisory, of course, but it also involves being playing a crucial role at the product structuring level, working on data transfers, whether cross-border or not, and advising businesses on how to develop and implement privacy and data protection compliance programs. So that's a very quick introduction to myself and my work. What Samir and I thought we could do is maybe jump to a couple of the key concepts, the key legal issues that arise out of this new law, maybe set the context of how this applies to global businesses that perhaps do business in India, and what businesses can start doing or start thinking about to ensure compliance. So, Samir, do you think that works from an agenda perspective?
Yeah, yeah, absolutely. Of course, let's get started, right? Why to wait for something that exciting? So let's talk about legal aspect of the law and the scope. Scope is the major thing. Scope
Yeah.
for companies in India. Of course, we are focusing this also internationally for the audience because I think there has been a lot of material put out there for local. But let's cover quickly, right? What is the status of the law, first of all, right? I think it has a presidential assent, but I think I'll let you explain
Okay.
where we stand, both for local, right, domestic as well as international company. And when I say global, I think every company is global, right? So either they are running out of India, US, UK, France, Paris, doesn't matter. I think international, everybody is, almost most of the companies are global. So I think there is a lot of aspect there we all need to learn and real dive into. So please go ahead. Let us state what is the current status of the law in a very. I know it's passed in the parliament, but
Yeah.
please talk in your language.
So, quick status check on where we are with the law. The Digital Personal Data Protection Act was passed by the Indian Parliament last week, and it received presidential assent last week. However, it is not yet in effect. The government will implement the law in a slightly phased manner. So, the expectation is that some of the more administrative aspects of the law, such as, for example, setting up the Data Protection Board of India, which is the authority that is tasked with enforcing the law, um, you know, we expect the DPDPB to be set up first. And effectively, what this means is that businesses are not required to comply overnight. There is going to be a slightly phased approach to compliance. The government will bring about different provisions of the law into effect over a period of time. So I would expect the next 6 months to 1 year to be very, very busy for companies that are thinking very seriously about data protection compliance. But I just want to set the record straight that right now, at the moment, the law, compliance is not expected at the minute. Now,
Absolutely. And when you say DPDPB, I just want to make sure for international audience, you're talking about DPDPA is Act, right? Digital Personal Data Protection Act, and B is the
yes,
board, right? So you are
yes.
all waiting on basically setting up the board on the enforcement side. Please go ahead.
Absolutely. Now, just before we jump into some of the frequently asked questions that we get about the law, I think a quick takeaway is that this is the fourth or the fifth iteration of a law in as many years. So we have seen different forms of the law, and this is definitely a business friendly version of the law. It does come with its own set of compliance challenges, but by and large, my takeaway as a lawyer and as somebody who works with companies, who try to set together programs, there is, in a lot of ways, this law is workable. It is practical. Now, that might open up another bag of controversies, but I'm not touching upon that. From a business perspective, I think this is a workable draft, and I do think that with a little bit of tweaking, a little bit of initial effort and investment, companies can get up to speed. So that's the takeaway. Now, the next question we often get is, how does the law apply? Now, one of the key features of the law is that it applies extraterritorially. It can apply to businesses. We are seeing that across the world with global data protection laws at the moment, is that it applies to businesses that process personal data of Indian residents or that offer goods and services in India. So you do not need to have an office in India for the law to apply to you. So that's a key aspect. The second issue, or the second concept that I think would be helpful to touch upon, is the different categories of companies or entities that are regulated under the law. Now, you have data fiduciaries that are very similar to the concept of controllers under the GDPR. These are the companies that determine the purposes and means of processing of personal data, and they are tasked with overall compliance under the law. You have a category of entities called data processors that process personal data on behalf of data fiduciaries. So these are your service providers. I mean, these are crude examples, of course, but service providers, outsourcing partners, SaaS providers. In a lot of instances, these kind of solutions will classify the company that offers them as a data processor. You do have another category of data fiduciaries called significant data fiduciaries, which, because of the volume of data they're processing or because of the sensitivity of the data, will be subject to more enhanced compliance obligations under the law. So broadly, the law regulates these three categories of entities. Now, what kind of entities are impacted? What are the industries that are impacted? Very, very broadly, any company that offers services in India would be impacted. All employers or all businesses that have employees or personnel in India, regardless of your industry, would be subject to this law. Any consumer-facing business, such as a financial institution, somebody involved in advertising, e-commerce entities, would of course be subject to the law. Service providers like SaaS players, for instance, may not directly be regulated under the law, but will definitely be subject to contractual commitments that would require them to implement compliance programs. So what we are looking at, therefore, is extraterritoriality, a fairly wide scope in terms of entities that are governed and regulated by the law. I do also want to point out that the scope of personal data is very, very wide. So the moment a business on some level is handling personal data of Indian residents, there are questions of applicability that comes up.
Yeah, and it does cover your employees in India, right? So if you are,
Absolutely.
so what's the definition of processing? So we'll get into cross data border transfer. But so first of all, it's a unified, right? The like a central, we call it federal kind of data protection law, which covers pretty much every company. Of course, the companies which are larger, I think there was a statement out there, right? Big tech companies and companies who actually do the business. So when you say significant data fiduciaries, who actually process personal data for some tangible benefit, right? So things like data brokers,
Yeah.
data exchanges, and stuff like that. But it's not like that. That manufacturing company does not apply because we don't have, right? They still have employee data. Then e-commerce shop, of course, you have all kind of e-commerce transaction. They're kind of heavy, so nobody's kind of exempt, right, from the industrial segment. And still, say for example, depending on the sectoral regulation like RBI, they will have their own kind of basically the laws. But I think we'll get into that as we go more. So anything else from applicability and exemption perspective, Adya? Did we cover everything?
I do want to point out that in respect of certain operations, you can be a data processor. In respect of certain operations, you can be a data fiduciary. So for example, a SaaS player that offers a SaaS solution to an enterprise could perhaps be categorized as a data processor, but when they are processing the personal data of their employees, they would be a data fiduciary. So it's not, it's not your categorization depends on your processing function, much like other data protection laws. So that's something businesses should keep in mind.
Good. So if I'm, say, for example, global sourcing company who's helping to source data globally, but I do have Indian employees, absolutely that. And how about the Indian citizens actually traveling worldwide, right? Where does it applicability actually stands there? Can you get a little bit perspective on that? So, for
So actually,
example, you're like Indian citizen went to Europe, went to US, right? Overall, and I know it all depends on where you have entities where there are like more stricter kind of enforcement than where you have office versus not. But how about that?
So again, I am. This is a slightly technical argument, or a legally technical argument, but effectively, how the law applies is it applies to the processing of personal data within Indian territory if the data is collected in digital form. That's number one. Number two is it applies in an extraterritorial manner if the processing is in connection with offering goods or services in India. So, an Indian company that is processing the personal data of an Indian resident traveling abroad, you are bound by the DPDPA. A company, say, headquartered in Spain, that is processing the personal data of an Indian tourist, when that Indian tourist is in Spain, it will depend on the nexus of their offering of goods and services in India. So it's not a straightforward answer. You would have to undertake an assessment to figure out if there's a nexus to how you offer goods or services in India.
Yeah. So I do have a subscription-based service, which is actually based in, say, for example, Australia, but I have 1 billion, maybe, 100 million Indian subscribers. I think that's a big volume, right? So there is
Absolutely.
no like, I know it's still working out, and I think we'll see a lot of different things when we actually as it more laid out. But thank you
Absolutely.
for that because I think that definitely is a kind of important question. Now, let's get into a little bit of cross-border data
Yeah,
transfers and localization requirement. I know there is some relief for localization. Localization is big deal, except sectoral, financial
absolutely.
sector or whatever kind of. But let's talk about the data transfer and then we can touch upon the localization requirement.
Yeah. So, with cross border data transfers from India, um, instead of having adequacy decisions, what the government has done is relaxed your cross border data transfer restrictions. So, effectively, businesses, companies are free to transfer personal data outside of India, except to companies that fall within a negative list that will be created by the government. Now, which countries fall within that negative list, we don't know yet. We are expecting further guidance from the government. But right now, the ability to transfer data outside of India is fairly relaxed. What is also important is that there are no general data localization requirements under this law. The previous versions of the law had localization requirements. It was very controversial, so that has been done away with. But that aside, you do have sectoral localization requirements. So, for example, in the financial industry space, you do have localization requirements that are prescribed by the RBI. So those don't go away, but they're just no general data protection, general data localization requirements. One thing I do want to flag, because I think this really impacts companies that do cross-border data transfers, is whether the DPDPA changes or impacts the way we think about Schrems 2 post Schrems 2 data transfers to India. So for those of y'all who are aware, post the Schrems 2 decision in the EU, personal data transfers outside the EU and UK have got a lot more complicated. India is not, as of now, an adequate country for the purposes of EU law. So to transfer personal data of European residents to India requires businesses to undertake a transfer impact assessment or a transfer risk assessment. Unfortunately, the way the new law is structured, this position will not change. The interception laws remain fairly untouched. The government's access to data remains untouched. And by and large, the government is exempt from most provisions of the law. So the way you think about data transfers to India has effectively not changed. I expect companies to continue to be required to undertake transfer impact assessment, transfer risk assessments, and implement supplementary measures when transferring personal data to India. So that's cross-border and localization requirements in a nutshell.
Yeah, so just to summarize, right, there will be I mean, there is some kind of a if and but, right, what countries and what, and I don't think there will be any clear definition yet. It's just too preliminary, kind of primitive to actually guess that. But I think that's a global trend, right? Who do you basically do business with geopolitically? What is? But I think one good thing about which is kind of pro business is there is no mass kind of data transfer kind of overhead, or rather, you still need to basically follow protect the data of Indian citizens, but at the same time, it's not restricting you to do a cross-border business right from day one, right? So you can do, and that's very basically business friendly or even logical from the perspective where India is the largest tech hub, one of the largest tech hub out there where, I mean, global IT companies, I don't think there will be a company who does not have office, right, in where you are in Bangalore or Pune or wherever in India, being playing such a kind of large role. Anything we missed there from across? So I think you were talking a little bit about strengths too, which is
Yeah.
kind of agreement between US and European Union, where there can be exceptions if you are under, especially for small businesses and mid-sized businesses where you don't have to. So, um, anything we missed there in terms of what they should be doing, or where basically they need to have a focus on, right? If
You
I'm
mean from a
basically a data
compliance
protection
perspective?
officer or a
Yeah.
compliance officer of a company like that.
Yes. So so the question we get is, I am CCPA compliant. I am GDPR compliant. Is that enough for me to be DPDPA compliant? And the answer is unfortunately no. And it's no, not because the law imposes very heavy compliance burdens, because in my view, it doesn't. But what it does is depend on a consent heavy architecture. Consent is the primary basis on which companies or data fiduciaries can collect personal data. Now, if there are very few limited exemptions, right? But by and large, companies have to depend on consent. I know you've got jurisdictions like the EU, for example, that have the concept of legitimate interest that is unfortunately missing in the law. Now, the fact that we are consent dependent means that businesses will have to rethink the way they interact with individuals, whether it's employees or whether it's consumers, because the thresholds for consent are also very high. Your days of having consumers like you and me, accepting a 20-page terms and conditions and claiming that that was valid consent, that's not going to be the case anymore. So there will require a real shift in the way we think about how consent is collected. That's for sure. Uh, just from a compliance perspective, you do have, if you are a significant data fiduciary, you will need to have a data protection officer that is based in India. So there is a certain level of residency requirements in terms of your personnel that creep in. And you do have obligations to make sure your data is accurate, to make sure that there's security controls that protect your data, that you report data breaches. And Samir, I think your perspective would be very interesting here, because when we are talking about data fiduciaries putting together compliance programs, and I'm sure you face this, but as lawyers, the primary issue we face is that most companies aren't aware of the data they have.
Yeah. So, yeah, I wanted to focus that, but I think, yeah, that's a very important aspect. I think very first step, right? What you need to know, what first of all is you're gonna do a risk assessment, like privacy impact assessment, data protection impact assessment. So, I think it's absolutely important that, okay, we collect that data based on some kind of interviews, questionnaires, and stuff. But absolutely important that when you talked about consent, and we'll get into one question I have there after I explain this. But very first thing is what kind of personal data you collect. Unless you know that, I don't think you can do a very effective privacy assessment. So I would say from the technology, I'll talk a little bit of technology perspective. If you are doing those projects out there, know your data. So it's basically a right time And I'll tell you, the insecurity space, right? Being data centric anyway helps you. So if you find out that, hey, what kind of personal data you have, I think it start preparing. And it's not an easy challenge. Of course, it's a big challenge because data is dispersed digitally. And I think IT is so busy, and security teams being protecting their infrastructure. I don't think everybody ever got a time on the data hygiene perspective of it. So it's absolutely important to know what you have before even you take kind of action in. So even if you talk about consent, you talk about any kind of right to know or right to erasure, right to delete, or basically whether data sharing aspect of it, you first need to know what data subjects you really have data on, because even for the businesses like marketing and stuff, you buy so much data, or you sell data sometimes if you are significant data fiduciary or data broker in this concept. So it's absolutely important that you have that and start preparing towards kind of doing your data inventories, and not just basically asking users, but also helping them, right? By going there, exactly doing those what we call data bill of materials. I highly recommend, please, if you search, I think the IAPP has a blog, right, which actually I wrote a year ago, called Data Bill of Materials or Personal Data Bill of Materials. Have that ready, and I think that's kind of gonna help you in a longer run, because once you know what the context is, then you also want to know where that data is being shared, right? What are your data flows? What are your, first of all, after you build a detailed data map? And I'll tell you a lot times what happens is businesses actually have more awareness and visibility of their data, which actually kind of makes money. And I don't think personal data is all about, it's about all data. So there is a lot of large amount of data, maybe structured, unstructured, but unstructured more. It actually does uh, is missing, and compliance perspective, it's absolutely important. And even if you see data breach side of it, you get to know, right? Oh, this data existed on this particular whatever data repository or something. So I think mapping and then also actually movement of data within your organization is absolutely important. And that's basically data protection officer, CISO, where you function. I think it can be a whole different topic where the technology and IT and compliance and legal should stay in. But I think it's a very techno-legal aspect, the whole privacy. More I got into it, I kind of mesmerized me that how complex it can be, whether it's a front end, back end. I don't think lawyers can solve all questions, or even technologists can solve. So I think there is a good collaboration kind of needed here, and that's what we are doing right. Other things to basically do is data minimization. I think that's the main thing in the law. There are a lot of aspects in terms of that. So do you really need data about data subjects, and why you are collecting that data, why you are storing that data? So I think it's time to get organized and also clean up, right? What kind of data is needed for the business, and all that. I think we are getting a lot of kind of interesting questions there here. So I'm pretty sure we're gonna have a lot of that. I just will make sure that I covered the most. But please, we gonna do a more larger technology session in future, because it has its own kind of. So I think let's get first basis covered in terms of the legal aspect of it, and I'm pretty sure we must have there is a lot to talk about in terms of right to. But I do want to stress, right? Say, for example, me as a citizen or consumer perspective, I have a right to exercise rights on that data, right? One way or other way. Now, how that's enforced, it's up to you, but you do have a legal ground which actually did not exist and don't exist in many parts of the world. So it's really exciting times for every Indian there, right? And globally, that they can now say that, hey, own data, and especially with data collection practices, right? I'm there almost every other month, shuttling between our India as well as US office. Everywhere you go, right? Your phone number is being asked, right? Good thing is they all ask about OTP. The awareness about two-factor authentication in my last security life is pretty good. But where this data is kept, right? You go to a building, enter a building, you don't know what that building management system is because it's shared among offices. So I think this was kind of necessary. So I'm especially excited that at least you have a right, whether it's residential, commercial, doesn't matter. Everybody wants your mobile number. And actually, I think that becomes your Aadhaar or social security number, especially in India. But I think you will get into that eventually. So let's basically talk about some data principle rights since we already got on that topic, and that's our last topic before we do a Q&A or basically dig down on some more stuff. So put us that, hey, I'm a citizen, I'm a consumer, I'm basically a bank account holder, or I am having some service where I need to give my data, where that data, whether it's basically I'm making a copy of my document, how the law makes responsible for basically data, the entities who are collecting data about my own data. I think that's the most important aspect here, and that needs to be exercised in its intention.
Yeah, with data principal rights, and for those of you all who may not be very familiar with the Indian law calls data subjects data principles. Samir, I think I'm a little more cynical about the data principal rights because when you look at the law, I think it's a little narrowly worded. So there are two broad concepts. Unlike any other law, there are duties on data principals, and data principals can actually be fined up to about 10,000 rupees for making frivolous claims. But that's one point aside, right? You do have rights of data principals. So you broadly have the right to access personal data. You have the right to seek the correction and erasure of your personal data. You have the right to grievance redressal. You have the right to nominate people who can exercise these rights on your behalf if you are incapacitated. Now, the right to access, the right to correct, the right to seek erasure of the data are great rights. The only problem is that the way the law is worded right now, these appear to apply only if the company or the business that is holding your data has relied on your consent to collect the data in the first place. What that effectively means is, and questions therefore arise, is that in an employment context, can I exercise these rights against my employer? Or if I have given, or this data has been processed by a hospital in the case of a medical emergency, do I have the ability to exercise these rights? I could be nitpicking because I think, lawyers, but there is definitely an ambiguity that arises in respect of how effective these data principal rights are going to be. That said, this is a huge step up from what we have at the moment. And what that also means is that data fiduciaries will need to have systems in place that will know exactly what data they hold. And Samir, I think that comes back to your point, right? The data mapping issue is that you can't have an effective data principal rights systems in place if you don't understand where your data is. You will also need to ensure that the data fiduciaries you share data with, or the data processors that you share data with, your systems and your contracts are designed in a manner where if a data principal comes to you to say erase the data, you have the ability to make sure your partners and your processors also comply with those requirements. Now, this is par for course internationally, less so in India. So it will force us to, rethink how we think about contracts, how we think about partnerships as well.
Yeah, and I'm glad actually you mentioned that, right? Because a lot of people overall, where you actually are what I call those some kind B2, B2C companies, right?
Yes,
So you
yes.
do actually store data, right? Because say you are shipping a package and it's basically moved on to the next carrier. That carrier needs that data, right? His address, where to ship, and all that. And enforcement of that is eventually going to come to the legal kind of enforcement when it goes bad, right? Whether it's a data breach or whether it's kind of exercising of rights. I think there is a lot of unawareness there. But in terms of that, I think we'll all get there. I do understand, but I
Absolutely.
think it's a first step there to get there. But at the same time, I think regulators want to make sure that people don't just make this
Misuse.
lawyer business in terms of harassing companies or something like that. So that's absolutely important. But one thing I want to, before we actually take audience questions, one thing I want to see, right, the consent you talked about. And I think data subject or data principle is at the center of any privacy, right? It's my data, my rights, in terms of that. So it actually relies a lot on consent. But how about the deemed consent versus, right? Consent can be also a little bit gray area, that what you call consent, what you don't. And I know there are no practical or rather real answers there, because I think law is a field, right? That's why we
Yeah.
need all uh, lawyers to interpret and the precedent and all that. But what best we can do in terms of deemed consent versus assumed consent, or whatever you call, versus the, so what, how does law define that?
So, very broadly, publicly available data is exempt from the law. Now, this really opens up another can of worms, because what is publicly available data? If I'm making my information available on LinkedIn, is that publicly, so that is one aspect of it. The other aspect is where you voluntarily provide data to a data fiduciary. They are not, if I voluntarily provide data to a data fiduciary, yes, I think the law at some point in time used the term deemed consent, but you don't need to take specific consent in those scenarios. Now, this framework is borrowed from Singapore law. It is, I think, going to be a very useful catch-all ground for processing personal data. Right? I can see a lot of businesses that are trying to simplify compliance to rely on voluntarily provided data being deemed consent as a ground for processing. I am not very sure about how it's going to work practically and what the corresponding obligations of these data fiduciaries are going to be, because, like I said, as you said with the data principal rights, right? If if the data hasn't been collected on the basis of consent, technically a strict reading of the law indicates that you might not need to provide these rights to data principals. So it does open up a lot of questions, but yes, it's definitely a ground, and a fairly loosely worded ground that can be relied upon, where individuals voluntarily provide data.
So I do one question, which actually kind of, and I know we'll go through that sequence, but I think this makes a kind of, so I think there is one important part in the law, and correct me if I understood that wrong or right, is anonymization part, right? I think
Yeah,
it does not mention
it
that,
does
hey,
not.
anonymized data is mass. And I'm
Yeah.
telling, I mean, I'm basically, what I'm saying is, there is a mass misconception, kind of, that, hey, something is anonymized, right? Everybody tries, or rather you can say that, and most of the data brokers, I don't want to name the names, but under the anonymization part, right, where if I can use that data in the manner where it's anonymized, it's not subject to the law, right? So I think law does not say that whether it's anonymized data allowed versus not allowed or something. But can you put some legal kind of perspective on that? I think that's a really good question in terms of or a good topic, that, hey, how do you classify anonymized data versus non-anonymized data, or just plain data?
Okay, so anonymized data is personal data that has been processed in a manner where there are no identifiable characteristics. I cannot, under any circumstances, identify an individual from an anonymized data set. Sunny, you will be able to comment on this better than I can, but my understanding is that there is no anonymization technique that is 100% foolproof. Right, you cannot 100% guarantee it, but the principle is right. It's that if I am saying that there are 35 people between the ages of 20 to 25 working in this office, do I need to extend personal data protection principles to that category of data? I don't think so. Now, again, you're right, the law does not treat anonymization very well. But the rule of thumb is that if you cannot personally identify an individual from the data, then the data protection law doesn't apply.
Yeah, and I think anonymization is always been kind of theoretical concept because
Yeah.
see, if you need a use, so I'm of a, I mean, this is my technical opinion overall, or expert opinion is, if you need a personal data, use it, right? Use it responsibly, right? We don't need to basically dance around that. Okay, I only have this because eventually, if you want to do say personalization, give somebody better user experience, you want to give some services and all that, then I think we gotta admit, okay, I need that because eventually there has to be a reference record for that data. Whether any technique you kind of take, right? You take this versus that, and I know a
Yeah.
lot of a legal ground or rather can be argued on that. But what I'm saying is, regulators and also in terms of that understanding that what is the intent out there, right? If you are giving some services and you have a consent, yes, use that responsibly data and protect it, right? It's not that hey, you have anonymized data and entirely all data protection controls kind of go away because this was never a personal data. Technically, yes, you can argue in the wherever you want to, either it's regulator or court or something. But are you doing your due diligence in terms of protecting that data? Because your one database may have some anonymized and then other have a completely exactly regular tokenized like reference point. They are right next to each other and you're storing that maybe on the same. So I don't want to get into too much technical. Let's move on to the next question here, Adya. So you want to pick some questions from the which kind of aggregated manner where we can actually finish this on time, or
I
you want
don't
me to?
I don't think it's possible to address all the questions, and I just don't think we have enough time. But I'm happy to take them maybe one by one. Sameer, if you want to shoot the questions um, at me, what do you think might
Yeah,
be relevant? And I'll be happy to take the others offline.
yeah, absolutely. And please, I think if you comment on that, we'll try to answer on, but do take that, hey, this is not a legal session or something, talking on behalf of Spice Route or Adya, that this is not a legal
Yes, yes.
advice. That's what lawyers say all time, right? So, yeah, one gentleman asking here, will foreign banks storing a customer PI outside India will have to bring PI data back to India and delete it outside India? Uh,
So a foreign now, when you're talking about banks, it gets a little more complicated because you have the RBI's data localization requirement that applies. It's not a DPDPA issue; it's the RBI's payment data localization requirements that basically require all payment data that arises out of India to be stored in India. Now, a foreign bank that is perhaps processing cross-border a cross-border transaction is permitted to store the data outside of India. But again, I just want to clarify that this is not a DPDPA issue. It's a RBI payment localization issue and should be looked at from that front because it includes all payment data. It's not just personal data, for example.
And I think the lot of data protection law are modern, and I think this kind of set a context. It's not based on the only territory or the region or local, but it's more about who are the subjects, right? So if you're a university student going somewhere, studying in US, studying in maybe UK, I mean, you are a citizen of one country, and if that country has a law, right, at some point, I think those are all data principle or data subject based laws, all the kind of modern law. But thank you there. I think that kind of um, clarified thing. Are there anything like qualifications required for DPO? Are there is kind of any statement there who should be? I
At
think a lot of people from career aspect of it that, hey, where should I get certified? What makes me DPO? So do we have answer there that what somebody qualifies as a DPO? Does it have to be certain? Is there anything there?
So right now, the only criteria is you better be based in India because only significant data fiduciaries need to appoint DPOs. Other companies need to appoint grievance redressal officers. To be a DPO, there is right now no qualification criteria. Neither is there any for uh, grievance redressal officers. It's likely that that's going to change. There may be further prescriptions by the government, but at this stage, the only key takeaway is that the DPO must be based in India. Now, I'd expect that some form of training or some form of experience in this field becomes very important, but there are no express qualification criteria yet.
Okay. And I think they might be right. Otherwise, you don't want, just kind of, shared responsibility. I think it will all depend on how much data you process, you are significant versus whatever. Here is an interesting question. I think, yeah, I think, and Charmian, that concept of HUF, the Hindu undivided family, and I think I basically remember. Is that included in the law, and what's the context and impact of that? That's a good one and a pretty unique concept to India, right? And this kind of
Yeah.
states, right, that hey, am I CCPA compliant, or rather GDPR compliant? I don't have to do anything because that's a master of law, and that actually did not even come true with CCPA because CCPA had a household information as a PII. All right, personal data, right? So if you own a washing machine and you have a family kind of asset, so oh yeah, that particular IP or whatever, if it's smart, that does under. So let's talk about HUF, and if you can give some context for a global audience, what Hindu undivided family means,
Okay.
I think that will be good, and then get to the law.
The concept of a Hindu undivided family is it's a structure that is created for the lack of a better term, inheritance planning and property ownership, etc. Right? This is it's of course very India specific, but the idea very crudely is that members of a family form a form of an association, right? That's the simplest way to think about it. There are certain inheritance aspects and property aspects that apply here. I'm not going to pretend to comment that I understand the functioning of an HUF from a property or inheritance perspective. What is interesting from a DPDPA perspective is that the definition of a person includes an HUF or a Hindu undivided family, which means that if a Hindu undivided family sits together and decides to process personal data and determines the purposes and means of processing the personal data, they might be a data fiduciary. That said, processing personal data for personal or domestic purposes is exempt from the law. So, unless you've got an HUF that is undertaking business operations without incorporating an entity and therefore processing personal data within the family, then the DBDBA would apply to it. But by and large, and I mean, again, I would just think that that would be unlikely. I think, but I could be wrong. This I'm going to caveat caveat. But the idea is that processing for personal purposes or domestic purposes is exempt from the law. An HUF that is processing personal data for personal or domestic purposes is exempt from the law. The law would not, the DPDPA would not apply to it. If the HUF is processing the personal data in the context of business activities, then the DPDPA would apply to it.
So in short, right, if as a HUF they are owning a big business which process customer data, so that will be some interfere or
Yeah.
other kind of impact there. But if you are just a family within you, so basically family don't sue each other that why did you process my data in HUF contact. I hope I put that right, but of course I'm not the legal. So other thing is, did you reference that? So you made a fleeting reference effect of DPDPA on a shrink wrap contracts.
Yeah,
Could
click
you
wrap.
please
Yes.
elaborate a bit more on how new act would affect the way consent would take on this contract?
Very happily. So, right now in India, you still need consent. It's a misconception that you don't need consent in India to collect certain types of personal data. But the thresholds for consent under existing Indian law are extremely low. So effectively, I can require as a company, my consumer, to sign or to accept a 300-page privacy policy, and that would be valid consent for the purposes of Indian law. So, if you've ever used any app as a part of the user onboarding journey, you usually have a pre-checked box that says, I consent to the terms and conditions and privacy policy. Nobody ever opens those. Those days under the DPDPA are over. The DPDPA doesn't do away or does not provide any clarity on the legality of click wrap agreements. What it says is that consent has to be free, informed, specific, capable of being withdrawn. So basically, the standards of consent have to be such that a user actually understands what they're consenting to. I can argue that if I don't open up a privacy policy that is 30 pages while I am, during a sign up process, that is not valid consent. So companies will therefore be forced to rethink the way they take consent from individuals. You will need smaller screens. You will need very, very precise disclosures of the exact data sets being collected and how the data is being transferred. You will need to get separate consents. You will need to make the consent requests available in English and 22 other languages. Right now, even for a non-speaking English audience, I can have them accept terms and conditions and privacy policy. The legality has not been tested in India right now, but I'm saying that the law is thinking about all of these things and trying to redo it.
So that's a good one. Is there any context about like local? We have a state language, official state languages, to making those consent available in the local languages? Because if it's Marathi, if it's Tamil, it's Kannada, Telugu, right? So that's gonna be a big work there, right? If you want, what if I don't understand English? I mean, that may be possible. And so, is there any context about that in the law that it has to be in understandable manner where it can be interpreted that you got to support some local kind of language there.
Absolutely. You do need to make these consent requests and these disclosures available in English and all the other languages in the 8th schedule of the Constitution. So I think that's 22 languages, if I'm not wrong. So what that basically means is everybody better have very effective translators on board. So that's what you're
So
going to need.
we, yeah, or maybe we have a regional version of ChatGPT, maybe.
Absolutely.
Or okay, yeah. So I'm trying to see what kind of other questions here. I think we got another maybe like 5-10 minutes. We can go here, but why don't you pick yourself? I think they're so long. Adya here, so you pick the one you have, and I think there's a lot of thing about consent. I think we kind of dissected that way too much
Yeah.
in terms of, and I think it's gonna be evolving
Yeah.
topic. There is one question here, right? As a data principal, how will you know that particular organization is really deleting my data or not? That's a good from consumer perspective. Is there any way, or how do we ensure that?
Very practically, I don't know. I actually
Okay.
don't know. So
Yeah, so I think the only way there I would imagine is that if companies don't do due diligence, right? Maybe there may be a ground that they are not following the law, right? If they say they're deleting your data and you requested that, and they're not deleting, I think that's basically the law all about. Now, as a user level, how do you ensure that? Of course, there must not be, and it's not even possible for um, consumers as well. So I think somebody posted a reference for HUF, which is pretty useful there. Uh, I think we probably are good, but say the one thing I think gentleman says here is as access government will prescribe the manner in which consent notices should be given to a data principal. On the other hand, language used as may be prescribed. Does this mean that government may or may not make rules on particular subject? Is this a case consent notice? What approach should organizations take?
um, I would say wait for the government to create rules. Right? A lot of this entire law is a framework, and all of the operational requirements are going to come out of prescriptions made by the government. So I'm in a lot of ways very optimistic when I do read the law and I have a couple of questions. My thought process is okay that maybe we are going to have guidance, and we are going to have operational guidance from the government. So I do expect, even in respect of consent notices, for the rules to suitably address it.
Yeah, got it. One actually question, it was actually way up in, and thank you for asking, gentleman Anurag is asking. So, consent manager, I think that's a very
Yes.
unique concept in Indian context. We did not cover that. So, I
Yes.
think if I don't understand privacy, so yeah, maybe you can have that, or yeah, please explain the consent manager in legal terms and how does that impact and how it's. I think it's completely different, right, from
Yeah.
most of the laws out there.
Absolutely. So thanks, Anurag, for that question. Consent managers, for again, it's a new concept under the law. A consent manager is a data fiduciary. And what it does is enable data principals to exercise their data principal rights, including providing consent and withdrawing consent. Um, um, by interacting with other data fiduciaries. Now, who a consent manager is, that will be again prescribed by the government, because to be a consent manager, if I'm not wrong, you will have to be registered with. You will have to be registered. That's number one. Number two is, I think, a good example, though not very appropriate, maybe, is in the financial sector space. You do have account aggregators, which are tools that enable users to give consent and withdraw consent. I would think that the consent managers would fulfill a similar role or work in a similar manner. So I think that is the simplest analogy I can think of when we are thinking about consent managers. But again, like with a lot of other things under this law, we will have to wait and see and wait for guidance from the government.
Yeah. And it does confuse a little bit, right? By reading just like a consent manager, you may think that,
Yes.
hey, can you outsource that function itself, right? In terms of if I'm a consumer and I don't really understand. And it's complex, right? Sometimes what's consent and what to consent to and not. That's actually uh, uh, good. So one more, I think, last question we may be, or maybe another more, depending on we are almost going to the hour clock here. But are there any mandated mechanisms like DPA or any assessment to be performed before outbound transfers from India?
So the
I think
funny
you
thing,
covered that little bit, but just maybe.
yeah, and actually, so I always keep the law with me over here right now because it's good to constantly refer to it. But if I am not wrong, there is no positive obligation on a company that is transferring personal data outside of India to undertake some kind of adequacy assessment, either of the jurisdiction or of the recipient at this stage.
Yeah, I hope. Yeah, that's good enough. Anything we missed, right? We are almost at the end of the session. Adya, first of all, thank you so much. It's almost, I think, 10:30 there. So
Yeah.
thank you for waking. And absolutely, thank you so much from the folks who joined from all over the world. This is going to be ongoing discussion, both in terms of because, of course, India will be a global player now in data privacy as well, because we all need to talk about when we talk about GDPR, right? Since the how this data transfers kind of happen between. So you have to think that, yeah, there is a bill there, and we need to take care of that. So on that note, no, just I'll say thank you so much, Adya, and of course Matthew and Spicer Out Legal to make you available and you personally being spending time with us. I think we will need one more version of this,
I
right?
expect
Maybe
so. We
Vish, and if yeah, if you think you want to basically please approach us, and if you want to basically be part of the discussion, I think it's live is absolutely it takes effort to make a live session, but I think there is a fun with it.
absolutely.
And I know there are a lot of kind of fines. I think we may close since we have 4 minutes here. I think I was about to ask and kind of I lost the track. How about we talking about the fines, right? Because that's the most important part. Everybody or we kind of think about that. What if I don't do this? How much I'm getting fined here? Maximum, minimum, what does it mean? Before we
Uh,
actually
Fines are extremely high. So the highest fine is about 250 crores, 250 crore rupees for a breach, I think, of to fail to report data breaches. You do have varying fines under that as well, right? So the fines go, I think, alternate between about 50 crores to 250 crores. The government also has the ability to double the penalties, and they also have the power to block platforms that don't comply. So while there are no criminal sanctions, I think the civil penalties and the sanctions you're looking at are scary enough, and I think unheard of in in recent times. And
is
also,
there
no,
any
there
kind
will.
of
Mhm.
yeah, the one interesting part, right? So GDPR puts like 4% of your global revenues or
Yeah.
something. So it doesn't matter you're a small company or large company, government can fine you. Um,
Yes.
yeah, anything between because that may be a do or die situation, right? If you get wrong knowingly or kind of unknowingly. Yeah, yeah, I know this discussion can, right? We originally planned it for 45 minutes. I know we already went over kind of 12 minutes, but I think this warrants absolutely some kind of update. I think the once data protection board will come in picture, and I think this is gonna have a really good turn. This is election over year over there, so I think lot many things gonna come become even more interesting overall. But absolutely, thank you again, and enjoy your evening there in Bangalore until it's there, right? So thank you so much. Hi, everybody, for great comments out there and attending, taking time. Please be engaged. Really nice to have, and I really enjoyed the session
Thank you
here.
so
And
much.
I'm yeah, I'm sure Adya enjoyed too. To give some free legal advice, maybe we can call you or your colleagues again. Thank you so much.
Thank you. Thank you for having me.
Yeah,
Take
bye
care,
bye.
everyone. Bye bye.